VA may reopen as many as 90,000 appeals, and there could be major back pay at stake. If you receive notice from VA that your appeal is being reopened due to a case called Freund versus Collins, you should respond immediately. If you find you need assistance to pick up your appeal again, please contact us. You can request a free case evaluation at cck-law.com. Here's a quick recap of what's at stake. For decades, VA's older legacy data system, VACLs, ran an automatic monthly sweep of active appeals. If it didn't show a timely substantive appeal or VA Form 9 on file, it closed the case, often with no letter and no notice. The problem is that many of these appeals were filed on time. VA had just been slow to manually log the paperwork. In March 2026, the U.S. Court of Appeals for Veterans Claims certified Freund versus Collins as a class action, turning it into a nationwide settlement case for veterans with appeals that were closed in error. In April, VA published a notice on the proposed settlement. That settlement says that class actions covers appeals closed between December 12, 1990 and February 6, 2025. If you were appealing during this period but never heard that your appeal was closed, remember, not all veterans were given notice. The court will be reviewing the settlement terms at a fairness hearing on August 13, 2026. But VA has already started proceeding, which includes auditing 28,000 flagged files and sending out notice to about 64,000 more. Veterans are already reporting receiving letters. If you get one of these notices, here's what to keep in mind. When VA confirms an appeal was closed by mistake, it reactivates that appeal. That means you pick up where you left off instead of starting over. Because a reactivated appeal is treated as if it was never closed, if you win the appeal, your effective date reaches back to your original claim. For some veterans, that could mean years of retroactive benefits. So what should you do? First, if your contact information with VA might be out of date, you should update it right away. Second, if you get a letter that mentions Freund, don't ignore it, even if the appeal is decades old. Third, if no letter arrives but you still believe your appeal was closed by mistake, the settlement does give class members a limited window to ask VA to review your case. All of these deadlines matter and the paperwork can be technical. That's where an experienced VA-accredited team can help. CCK Law can review your notice, help confirm whether your appeal was affected, and represent you as your reactivated appeal moves forward. While past results do not guarantee future outcomes, we've had favorable results in 98.5% of our actions before VA and a 95% win rate in federal court. We've recovered over $1 billion in compensation for more than 36,000 clients since 1999. So if you get a Freund notice and aren't sure if you can follow through on your own, please get in touch. You can contact CCK Law online at cck-law.com.